Okay, so welcome you guys to this little estate planning 101 class. This is a class that normally my associate Natasha Hazelit and I would teach in a 2-hour session. But today I'm just going to give you 30 minutes worth of stuff. You know, we're going through this COVID-19 crisis. It's very, it's a new situation for everybody. And we thought, let's talk a little bit about estate planning. It's probably a little more relevant for some people than it was maybe a couple of weeks ago. So I'm going to give you some mistakes that people make with estate planning in about 30 minutes. First of all, of course, I wouldn't be a lawyer if there wasn't a legal disclaimer, right? So the legal disclaimer is everything I'm going to tell you. I am not here to give you legal advice, okay? This is just general information. And if you have more questions, you are welcome to call our office. I'd be happy to talk to you about it in depth, talk to you about your personal situation. But this is just general information, okay? So now I've done my disclaimer. So my name is Sheli Fulcher Koontz. I'm an attorney at the firm of ANGSTMAN Johnson. I've been practicing law since 2001, and part of my practice is estate planning. The other part of my practice is family law. So we have drama and death. So that's how I balance that. Anyway, I have been practicing here in Idaho for since 2001. And my colleague Natasha Hazelit and Natasha has been practicing estate planning with ANGSTMAN Johnson for many, many years. She is an exceptional estate planner, and she currently is of counsel with our firm and is living in Tennessee. And she and I collaborate on estate planning cases together. And she developed this curriculum, and she's been teaching these classes through community ed for many, many years. And now I'm helping her out with that. So one of the things when Natasha and I started talking about mistakes that people make with estate planning is the big difference around the country of how people view estate planning. Here, I have to admit, I was raised in the West, and estate planning wasn't really a thing that I thought about when I was younger. Where Natasha, she came from the deep South. She came from Mississippi and Tennessee. And, there, when you get married, oftentimes one of your wedding gifts is an estate plan. So when she moved out here, she realized, there's just a lot of things people didn't know, didn't focus on. And that's what prompted us to come up with some mistakes people make and get people some education. So some of you guys may have had someone in your family pass away or know of somebody that has passed away. And after that happens, death can be what's called a crisis time, okay? And obviously I can't see all of you, most of you aren't on video, but I'm guessing that several of you have been involved when otherwise rational people start to behave very irrationally when either a parent dies or someone in their family dies. And here's the thing, if there is no plan, if the person that has died had no estate plan, guess what that is? That's a recipe for a potential hot mess. Hot mess. And you know that sound, cha-ching, cha-ching, cha-ching? If you end up in the hot mess because there's no plan out there, that's the sound of the legal fees that can be incurred for failing to plan. And you're like, well, Sheli, I'm going to be dead. I don't really care. Guess what? If you're leaving family behind, loved ones, you're leaving a hot mess for them. And it's probably not your intent that whatever estate you had, you left for huge legal fees to incur because you just punted and didn't plan. So my job is to lower those legal fees and get rid of the hot mess for you, okay? So let's talk about some estate planning mistakes that people commonly make. The first one is not having an estate plan. Not having an estate plan, which I am loath to admit I didn't have for a long time. It's like, and you're like, Sheli, you're a lawyer. What do you mean you didn't have an estate plan? I didn't have one because it's kind of like the cobbler's kids never have shoes. I just never really focused on it. And then I realized after I had a child, yeah, I need to start adulting and get an estate plan. So when I say estate plan, you're like, what's in an estate plan? A complete estate plan is going to include a general durable power of attorney. That is a document that allows someone to act as your agent for financial transactions. A healthcare power of attorney, which allows an agent to help make healthcare decisions for you when you can't. A living will, which deals with how you want the last few days of your life, the type of care you would like to receive. And a will or a trust. and or a trust. Okay, so there's generally 4 things that are going to make up that estate plan: the general durable power of attorney, the healthcare power of attorney, the living will, and the will and or trust. Okay, so again, we talked about when people die and they don't have an estate plan, that creates a lot of uncertainty. And uncertainty plus crisis or irrationality, what is that up to? Cha-ching, 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 hot mess. Okay, so that's the first mistake, is not having a plan at all. The second mistake people make in estate planning is, can you guess? It's using the do-it-yourself or the LegalZoom forms to do your own estate plan. And you're like, oh, come on, Shelley, we know this gig. You're a lawyer. Of course you're going to say that because you want us to come to you. Well, here's the thing. Go ahead and write your own will. Go ahead. Get one of those forms, write your own will. I don't mind, because frankly, I make more money fixing the mess that results from doing that than I do writing your will for you. Okay? So here's the reason why these LegalZoom forms, they are not often the best option for you. Now, first of all, in Idaho, can you write your own will? Yes, you can. You can do what's called a holographic handwritten will. Now, is it a good idea? No, not necessarily. Not necessarily. There's many a legacy that's been tarnished by a messed up document, and it ends up being a mess you leave behind for a bunch of other people to clean up. All right? So these, and you say, well, I'm going to be gone. It really matters after you're gone what happens. Who's left to clean up whatever mess you left? All right? In terms of LegalZoom forms, those forms contemplate a perfect existence. How many of you guys have the June Cleaver, Donna Reed perfect family? You don't have any conflict. There's never been a divorce. There's never been a marriage, remarriage, and there ain't never been no drama. How many of you? I'm guessing almost none. If you are in one of those categories, congratulations, but the majority of people are not. And the downside of using these prefab forms you can get on the internet is they don't contemplate things outside the perfect box of Donna Reed and Beaver Cleaver, okay? So that's one reason why they can be a problem, all right? They don't answer all your questions. Like, I'm gonna give you some examples. These are actual war stories, cases that our office has had. We had a case where a gentleman, his neighbor had gone out and gotten a will done, and he said, hey, can I take a look at that will? So he took a look at the will and he's like, do you mind if I just copy this will? And the neighbor didn't know any better and said, sure. So dad takes the will, copies it out by hand, signs it, and all of that. Well, guess what? All the legalese in the will that he copied, it actually meant something. It meant something, okay? So this gentleman that copied the will, he had one of those his, her, and our situations. He had children from a prior marriage. His wife had children from a prior marriage, and they had children together. Not the Beaver Cleaver LegalZoom form scenario, okay? So when dad died and they went and looked at this will that he'd copied, guess what? Cha-ching, cha-ching, cha-ching. Because some of the things that had been in his neighbor's will didn't fit dad's scenario. Guess how much this family spent fighting over this will? Because dad just didn't know, didn't understand the language, didn't know what it meant, and it didn't fit his situation. Guess. Anybody have a guess? You can type in the chat box if you have any idea of what you think that would have cost. I'll just wait. All right, somebody said $50,000, $2,000. Guess what? $70,000 is what it costs, because all those kids lawyered up and contested the will, and the estate, dad's estate, paid $70,000 in legal fees. Okay, dad would have paid less than a fraction of that cost to have gone to a lawyer and had an estate plan created that fit his particular scenario, because he wasn't in the perfect little box. Okay, so that's one example why do-it-yourself can cause a hot mess and a big expense. Now here's another one. Daughter decides to write a will for her father. Okay, she gets one of those forms, writes it. She gives the estate to all of dad's children equally. and she misspells dad's name on the will just so it was extra classy. Okay, so afterwards, first of all these children, all these siblings, they don't get along. And that's often pretty common. Or when someone dies, they start to not get along. But she had written the will that all the children got everything equally. Well, she shows up in the office and says, well, you know, I know dad meant for me to get my mom's jewelry, so I'd really like that, but my siblings are pitching a fit about it. Well, guess what? She didn't put a specific bequest of jewelry to herself in that will. So guess what we had to say? Draftman's error. You got to split that estate equally, and you may not get mom's jewelry unless everyone else agrees, and nobody agreed. So again, cha-ching, 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 lots of expenses for things that could have been easily avoided if we weren't trying to necessarily do it ourselves. Now, the third example I'm going to give you is we had a gentleman that got an online financial power of attorney for his wife, because his wife was getting more and more forgetful, had been diagnosed with dementia, and he was worried about being able to handle financial transactions for his wife. So he pulled one off the internet, got her to sign it. Well, then she ended up in a care facility and had full-blown dementia, was no longer legally competent, which means she couldn't make decisions, sign contracts, do financial transactions. So husband decides he needs to sell the house to pay for wife's care. He takes this general durable power of attorney down to the bank and says, okay, I'm the agent for my wife, and I'm going to sign the closing documents at the real estate closing. And guess what? That little Google JD that he'd gotten for himself didn't allow the transfer of real estate. So he couldn't use it. Well, now he's got a big problem because he's trying to sell the house and wife can't sign the closing documents because she's not competent. Okay. Had he come to an estate planner and said, this is what I need, they would have made sure, or I would have made sure, that there was a provision in there that allowed him to sign and transfer real estate interests. But he couldn't. So now he's got an incompetent spouse and a big mess on his hands that he now had to deal with and spend a lot more money because he used a form that didn't contemplate his situation. So again, those forms, unless you line up perfectly within the box, they're a problem. The other reason they can be a problem is every state handles estate planning a little bit differently. Idaho's a community property state. We're only one of 9 in the whole country. The rest of the country aren't community property. So if you happen to pull a form off the internet, you don't know necessarily that it's contemplating Idaho law. You know, if you live in a state like Louisiana, you almost can't use any of those online forms. They're under a completely different law system than the rest of the country. So that's the downside of using those forms. You don't know if it's going to work for you, and oftentimes you spend far more money after the fact because you thought you'd save it on the front end. So that's why that's a mistake. Now, the third mistake that people make is they don't necessarily specifically plan for the distribution of stuff. Stuff, we call that tangible personal property. That's stuff like this, or like, you know, your jewelry, things like that. Now this deals with things like high market or sentimental items. I'm not talking about cash. I'm not talking about real estate or stocks or bonds. This is actual stuff. Okay. And this typically is where big cha-ching, cha-ching expenses can come up in estate planning, because people tend to fight over the stuff you'd never dream in a million years they'd fight. People will come and see me and say, well, Shelley, my kids aren't going to fight about anything. I'm like, I don't know. You think they're not going to fight about stuff, but you don't know. So I'll tell you a little horror story. All right, we had a lady, lovely lady with 5 adult daughters, and these women are in their 50s and 60s. Mom passes away. All right, well, things turned into a hot mess. Mom had a will, but mom didn't provide and distribute a lot of her tangible personal property or her stuff. So long story short, we end up in what are called depositions. Depositions are sworn statements under oath when you're in the middle of a lawsuit. So we've got a client come in, and the client's having her deposition taken, and a lawyer says, Ms. So-and-so, isn't it true that on such and such date, after an argument with your sister, you pulled down your pants and mooned her? I'm like, what? What? And isn't it true, Miss So-and-so, that this happened not once, but twice? Client bursts into tears, gets up, runs from the room, and the lawyer says at the same time, and isn't it true this was all over a dispute about sun catchers? And I'm thinking to myself, what's a sun catcher? Turns out sun catcher, those little stained glass things with the suction cup that you stick up in the window and the sun comes through them. And mother apparently had a lovely and huge collection of sun catchers. And even though they're not worth a lot of money, apparently her daughters had some serious emotional attachment to mother's collection. Mother also had an extensive collection of Barbie dolls and Christmas ornaments. None of that was provided for in her estate planning. Okay, so guess what ends up happening? Big conference room, 5 lawyers, 5 angry adult women that have been reduced to mooning incidents, and it ends up 1 sun catcher for you, 1 Barbie doll for you, 1 Christmas ornament for you, for a whole afternoon of that, huge legal fees, and mother's probably rolling over 2 or 3 times in her grave that that's how her children are spending down her estate. Okay, so here is a little visual aid. This is called a tangible personal property sheet. Okay, and the nice thing about a tangible personal property sheet is when I do estate planning for people, it's a list, and the list is referenced in your will, and your will references this list. And you can put whatever you want on this list whenever you want to put on it. You can say, Grandma's gravy boat is going to Sally. Okay, and then you might change your mind and say, no, you know, Sally's not in my good side right now. I'm not giving her the gravy boat. You can go in, strike Sally's name out, start a new list, leave it off, and it's perfectly valid. And guess what? You don't need to come see a lawyer every time you want to make a change like that. So for things like your stuff, you know, again, not stocks, bonds, real estate, or money, but all of those items around your house that might cause huge fights with your children, one of these, in accordance with your estate plan, solves that problem and saves your estate a ton of money. And what makes it valid is both documents reference each other, okay? And all you do is sign it, and you don't need a lawyer to change it. And you also don't have to make all those decisions up front right when you do your estate plan, because that's where most people get stuck, is I don't know who to leave my stuff to and all that. Now, some of you say, well, Shelley, why can't I just go and put Post-it notes on the bottom of all my stuff and put, I want so-and-so to have this. I want so-and-so to have this. Well, it doesn't reference your will. This makes sure that when you die, the person in charge of administering your estate, we call that the personal representative, they can take this list and just go through it. Okay, and that's part of their job, is to go through that and make sure that everyone gets what's on that list. So not providing for the distribution of your tangible personal property can cost your estate huge legal fees, okay? And here's the other thing. You want to make sure that people want the stuff you want to give them, okay? And I'll tell you another horror story. All right, so Thanksgiving. My spouse and I are at my mother-in-law's house in Wisconsin. And she says, guess what, Shelley? I've decided that you and Mark, that's my husband's name, you guys are getting the egg because I'm trying to, you know, reduce things down. And when I die, you guys get the egg. And I'm like, the egg. Okay, the egg is not the egg. The egg is not the egg. The egg is like the egg. The egg is almost 4 feet tall. The egg is so big I can't get my arms around it. The egg is blue and pink and polka dotted, and people, the egg is hideous. Hideous. It's horrible. And I'm thinking, why in the world does my mother-in-law think that we want this egg? So at some sort of break in the meal, my husband and I are in the kitchen, and I say, why does your mom think we want the egg? And he's like, I don't know. I hate that egg. It's hideous. I'm like, I don't know. And I'm thinking, how am I going to get the egg from Wisconsin to Idaho? I mean, nobody wants, I don't want this egg. My husband doesn't want this egg. Well, after we return back to the table, it turns out it's not my husband that loves the egg. It is my sister-in-law, Darlene, that loves the egg. And you say, well, Shelley, what's the big deal? Just when your mother-in-law passes away, give her the egg. If only it were that easy. If only it were that easy. You know what's going to happen? Mother-in-law dies, God bless her. We get the egg. I try to give it to my sister-in-law, and she's like, oh no, mother wanted you to have the egg. And now she's all upset and angry because mother didn't realize that she loved the egg and she should have gotten it. And what's it creating? A hot mess. And if it gets totally out of control, cha-ching, cha-ching, legal fees. Okay, so when you are planning for the distribution of your tangible personal property and you're making out your tangible personal property list as part of your estate plan, ask the people that you want to give stuff to, is this something you'd want to receive? And you might find out that your children or whomever have a very different idea of what they love of yours and what they don't. Okay, so that's stuff. Now, the next estate planning mistake people make is selecting their oldest child, or worse, all of their children, to act as a fiduciary. And you say, what's a fiduciary? A fiduciary is somebody that manages somebody else's affairs. And they have the highest duties to do that under the law. They basically stand in someone's shoes and act for them. So there's 5 types of fiduciaries when it comes to estate planning that you can have. Most people don't have all of them, but you can have all. The first one is what we would call the personal representative. Some people call it the executor. In Idaho, we call it the personal representative. That is the person that is in charge of taking the will after somebody dies, having it validated by the court, and opening up a probate so the probate assets of the estate can be managed. All right? And so they are basically in charge with taking the will and doing what the will says. All right? That's a personal representative. Okay? Now, if you had a trust for some reason, the person in charge of administering the trust in accordance with your wishes is called the trustee. Okay, so you can have a personal representative and you can have a trustee. All right, if you have minor children, you can also have court-appointed guardians. They take care of minors or incapacitated adults. So if you had an incapacitated spouse and you died, the court could appoint a guardian to physically care for them day to day. Or you can also have a conservator. A conservator is also a court-appointed person that manages financial affairs for minor children and incapacitated adults. Now, the guardian and conservators, you can appoint those in your will, and these people, they have a big job. They have to go through federal background checks, a bunch of court training. They submit annual accountings to the court. It is a fair amount of work. It's a big job. So that's not something, I mean, if you're going to have one of those in your estate plan, you have to really think, who do I want to take care of my children? Can they take care of my children? Who can take care of my incapacitated spouse? Okay, so we've got personal representative, trustee, guardian, conservator. The 5th fiduciary is what we call an agent or an attorney in fact. Okay, and those come up under what are called powers of attorney. Now, a lot of people will come in and they'll say, well, I'm the power of attorney for my mom. No, you're not. That's like saying, I'm my mother's last will and testament. You're not. You're the agent under your mother's power of attorney, or you're the personal representative of your mother's will. So if you start using the right vocabulary right out of the gate, then if you ever get tasked with any of these jobs, you'll know the right words to use, okay? Now here, when picking a fiduciary, the biggest mistake people make is they will automatically select their oldest child, or they will select all children. But you really need to pick the right person for this job. You can't punt. If your oldest child doesn't do well with money, you probably don't want them managing your affairs. Okay? If you've got children that don't get along, having all of them serve together in this role is going to create a giant hot mess and a huge expense, because they're not all going to agree with each other. And they may have to go out and each lawyer up to work out and negotiate agreements, okay? So wrong choices for fiduciaries are people that, like I said, have no money skills. Maybe they live too far away. Most of my family lives in New Zealand, and so I have my brother who lives there doing some jobs, but he's not the personal representative of my will because he lives 10,000 miles away, okay? The other thing too, consider birth order. Okay, sometimes the oldest child is the right choice, but not because they're the oldest child. I will tell you a story from my own family. My dad is one of 5 siblings. My grandfather, for reasons I don't know that I'll ever understand, opted to make child number 3 the personal representative when he died. So 4 boys, 1 girl. Girl is the youngest. So middle boy, boy 3, gets made the personal representative. Well, siblings, brothers 1 and 2 always picked on number 3, and number 3 always picked on younger brother and younger sister. So when brother 3 got all the power, hot mess. And sadly, I will tell you that those siblings, pretty much none of them speak to each other anymore because there were so many problems with number 3 being the personal representative. So you have to consider birth order. I had a client once where the parents had a trust set up for each of their children. Parents died, and younger sister was tasked with being the trustee of older brother's trust. That it went as well as it could, but it caused a lot of problems because there was some resentment from older brother that little sister was managing his trust distributions. So just be mindful of that. You don't have to have family members be your fiduciaries. It needs to be people you trust. It needs to be people that can handle the job. Okay. And the other thing too is you can always choose a professional depending on the size of your estate. There are companies out there that do professional trustee work and professional fiduciary work in general, and they can be designated as your personal representative or your other fiduciaries. Okay. But here's the thing, make a choice. Don't punt this. You can have 2 people serve together. Sometimes that works out pretty well. You can have what are called co-fiduciaries, and your will can say something like, I want these 2 people to serve together. If one of them can't or is unable to, the other person can serve by themselves. So there's options out there for you. But here's the other thing too, ask these people if they want to be appointed. Okay, when people come into our office, I always get their first, second, and third choice for who they want to serve in these fiduciary roles. Why? Because what if your first choice dies before you? Or what if your first choice is in a medical situation where they can't take this job on? Or what if that person just says, pass, I don't want it. Okay, so it's always good to have a couple of backups in case your first choice doesn't work out. But talk to these people and say, are you willing to do this? I mean, there's no reason to spend money on an estate plan to have everybody pass on who you chose. Okay, so talk to your beneficiary or talk to your fiduciaries about taking these roles on and make sure that they are willing to do it before you just name them in your will. Okay. Now, another mistake people make in estate planning is feeling obligated to treat all of their children equally. Okay, if you've got differing relationships with your children, inheritance is a gift, it's not a right. Okay, you are not required under any law to provide equally for your children. If you've got a child that is around a lot, helps you with lots of things, and another child you're either estranged from or really is distanced themselves, you don't have to provide equally. Okay, Natasha was telling me about a bumper sticker she saw one time that said, being of sound mind, I spent it all. You don't have to leave your kids anything if you don't want. We have people that come in occasionally and they leave stuff to the organizations they were part of, friends and other family members that they really had great relationships with, and sometimes they don't provide for their children at all. But consider your children's contributions to you and your livelihood, and don't feel like you have to treat them all equally, because you don't. Okay. The next mistake is not specifying burial instructions. Burial instructions. And you're like, well, that's morbid. Well, what happens if you don't say whether you want to be buried or cremated at the very least? At the very, very least, what happens? You could have family getting crosswise with what they think you wanted. All right. So you don't want to have that. There's many, many options out there. There's cremation. There is, you can be buried, and there are things called life stones. And you're like, what's a life stone? So a life stone is, there are companies out there that will take ashes after you're cremated, and they put them in a big pressurized machine of some sort. And just like, nature, a lot of heat and a lot of pressure with carbon, which is what ashes are made out of, what do you get? You get diamonds. You could become a life stone. I told my husband, I said, well, that would be kind of cool. I could become a life stone after I die, but I think if you gave me to your second spouse, that would be creepy and weird. So maybe not that. but you need to let people know. And when we do estate planning for people, we do what's called a funeral letter, which, like your tangible personal property sheet, references your will references the letter. And I always put on the funeral letter whether you want to be buried or cremated. The rest of the letter, I leave up to you to fill in how you want your services to go. Do you want a service? Do you want flowers? Do you want this music? Do you want to have a big party? You know, whatever it is you want, you can specify in there. And guess what that does? It reduces conflict with everyone that's left. If you don't want a funeral or a service, you can put, I don't want in there. I don't want that in there. All right. And your personal representative has to do what's ever stated on your funeral letter. And these are things, other than a funeral letter in Idaho has to be notarized. You don't need a lawyer to change it. You just have to sign a new one in front of a notary to have it be valid. Okay. So, and the last mistake for our limited time we have today that I will go over with you is not updating your estate plan. Let's assume all of you are super organized. You've gone out and gotten an estate plan. It's been a couple of years. Where people get in trouble is when they don't pull that plan out and take a look under these circumstances: births and deaths, marriages and divorces. You know, if you've left everything to your spouse and you get divorced, you might want to change your estate plan. Okay. Incapacity. You've got a spouse that becomes incapacitated, or a family member. Maybe you want to review your estate plan to make sure that if you become incapacitated, your wishes are still what you want to have done now. Increased assets. You get lucky and win the lottery. You're probably going to definitely want to have your estate plan reviewed and maybe do something a little different. And then if you move to another state, remember, estate planning is governed by individual state law. A lot of laws are the same, but some are very, very different. So if you move to a new state, have your current estate plan reviewed by an estate planning attorney in that state. So just to make sure that if you happen to die in the new state you're living in, your will can still be administered the way you had intended it when you had it drafted here in Idaho. If you need to change something in your will, that's called a codicil. And it's just where you can take a section of your will, make a change that goes with the will. It's called a codicil. If you have a trust, a change to a trust is called an amendment. And all of those can be done. Sometimes you want to make so many changes, it's more cost effective to just do a complete will rewrite, but an attorney would evaluate that for you and give you your options. Okay. So those are some of the big mistakes people make with their estate planning. And I don't want to see any of you making those mistakes. So if you have questions, I can open this up for a few minutes of questions. And otherwise, you are welcome to call our offices at ANGSTMAN Johnson, and we'd be happy to talk to you about any of this. And if you don't have a estate plan, based on what's going on around us with this coronavirus, if that isn't a little glaring neon sign that says it's time, it's time, it's time, it's time. Okay, nope, you're absolutely welcome. So again, happy to talk to any of you if you'd like, but thank you for letting me come to you for a little bit today and talk about estate planning mistakes. I don't want to see any of you making those, all right? Thank you all. Have a good day.